Okay, folks, we are now going to begin the commentary that goes along with handout 17, which is the last handout for the course. Before I go into that, I just want to say something I forgot to say in the last video, which is in Rhode Island, the Office of the Secretary of State maintains probate court forms, standardized forms for all different types of matters before the court. If you go to the Secretary, just Google the Secretary of State of Rhode Island's website. In their search engine within the site, type in probate forms and a list will pop up, and you will see that as you go down the list, there is a form for a DMAT, there are forms for petitions for administration of estates, probates of wills, bond forms, complete administration forms. So just about any type of form that you would be using in the probate court appears there. And by and large, the judges prefer that we use those forms, and we do in my office use them for all routine matters. There are things that are not covered by the forms that come up in court, and for that you can create your own form that sort of parallels the setup that the probate courts use, but there is a standardized set of forms for the entire state of Rhode Island, and they are there for you to look at and get used to. Most of them are PDFs, they're downloadable, they're fillable so that you can type right into them and save them. Tremendous savings of time and money in some ways when you're dealing with probate practice. Okay, our final seminar today. I wanted to cover a few things. First of all, I wanted to talk about estates and how they are looked at and the different ways of looking at estates. And this is something that for the layperson who's not an attorney, it's very confusing, very difficult to make them understand. And even for attorneys who don't deal in this area, I've had discussions many times with some of my brother and sister attorneys who don't deal with probate work, and they kind of look at me with puzzled eyes as I begin explaining some of these things. There are various ways to look at your estate. Now, your probate estate is comprised of whatever property had your name alone on it at the moment when you died. And so that any jointly held property is not part of your probate estate, and anything that is a beneficiary type of contract, agreement, or property is not part of your estate. So if you had a bank account with your name alone on it, that would be part of your probate estate. However, if that account was held jointly with another person, or if that account had a payable on death person named, then it is not part of your probate estate. It is going to pass either through the bank's rules about joint accounts, or it's going to pass on death to whoever you named as being the successor. And the same thing applies to stocks, to bonds, to a whole number of annuities, insurance contracts. There is a whole realm of contractual property rights that exist outside of the realm of the probate court. Even in real property, if the property is held in a trust, if it's jointly held, if it's held as tenants by the entirety, the real estate does not become part of your estate. Property that is held tenants in common, your interest in that property would be part of your probate estate. So one of the things that we have to do when somebody comes in and says, oh, my relative died, my spouse died, I need to unravel what's going on, is we need to start taking an inventory of all the assets that that person had, anything that financially or property-wise touched their life, and we need to begin putting them into categories. And so one category is, all right, is there anything that is in their name alone? Because that is going to have to go through the probate court process, and we need to identify that right up front to make sure that we know that that's there. The next type of estate is the beneficiary estate. And as I said, most types of financial vehicles today allow the owner to name beneficiaries. So they can either have the property jointly held with another person, or they can, as part of their contract for this property, name who it is that they want to take the property when they die. IRAs, investment retirement accounts, 401ks, which are accounts that are maintained by an employer on your behalf for your retirement. These are by federal law and tax regulations beneficiary accounts. So they are almost never going to be part of a person's estate unless the person neglected to name a beneficiary. And that almost never happens because the people who administer and maintain these things are very good about insisting that a beneficiary be named. But we do have circumstances where the named beneficiary predeceased the owner of the account, and then the owner of the account never realized or did anything to update their beneficiary designation, and they die with nobody named as a beneficiary. In that case, it would go into their estate. For IRAs and 401ks, 401bs, there are tremendously big reasons why you may not want that to happen. Those are all accounts that can be set up with pre-tax dollars, so that when you earn the money, you put it in, you do not pay income taxes on them that year. However, on the year you withdraw the money, you have to pay taxes on the full amount. And of course, the bigger amount are income tax regimes on the federal level, and on the state level in Rhode Island and Massachusetts are progressive tax regimes. So the more money you own, the bigger percentage you owe in tax. The goal in setting up these accounts years ago was that you would pay the money in the years where you're in a very high tax bracket at your highest income capacity, and then when you retire, you would begin to withdraw the funds when you had a much lower income and hopefully be in a much lower tax bracket. If you allow these funds to fall into your estate, one of the unfortunate things that happens is that in transferring the funds over to the estate, they are deemed to be withdrawn from the accounts, and the income taxes due to the federal and state governments become immediately due and payable. If you name beneficiaries, they have a number of options to roll these accounts over, to let them become retirement accounts for themselves, and to not have to immediately withdraw the funds and pay taxes on them. So it is an important distinction, and something that, even though we may not handle these matters ourselves as attorneys, financial planners and the folks who handle the pension funds for our clients tend to be the ones who deal with them. As we're going through the process of setting up their estate plan, one of the things we want to do is discuss these items with them and to remind them, check your beneficiaries, look at the designations, make sure that they are done correctly. I've had several instances in my career, one where a gentleman worked for the post office for a number of years before he got married. Was married for 15 or 20 years, died of cancer, and upon his death, it was discovered that his retirement account and some insurance policies, he had named his parents as beneficiaries some 30-some years prior when he started at the post office, and had never bothered to change. So instead of the spouse and children receiving those funds, they went to the funds went to the parents. The parents and the spouse did not get along. The spouse never saw that money. I had another client where husband contracted cancer, knew there was a very good likelihood of him not surviving more than a year or so, came to us, set up a very elaborate estate plan so that nothing would have to go through probate court. We set that all up, everything worked. A month or so after the husband died, the wife gets a statement from an online investment account that she didn't know the husband even had. Turns out there was over $150,000 in that account, because he was basically using this money as his play money that he went online after work to play with and make accounts with. He never thought of setting up a beneficiary. So we had to open up a probate estate after all the time and expense that we went through to ensure that he wouldn't have to have a probate estate and go through the probate court. We ended up having to open up a probate estate for this one account. So it is a very important thing to discuss this type of thing with your client, and to make sure that even things that are not coming under their will are somehow taken care of and thought about, and that they've made a conscious decision. A trust estate. Any property that is in a trust does not go through the probate court, and basically when the person dies, if they were the settlor, or even if they had been the settlor, trustee, and beneficiary, a successor trustee takes over, a new set of beneficiaries are named, and things pick up and go along pretty much as they had before. If the trust had been a revocable living trust operating under the settlor's Social Security number. Once the settlor dies, the trust now usually becomes irrevocable, and we need to get a separate tax ID number, and the trust itself will be taxed as an entity. But there is no need to go to court, and again, one of the main reasons for setting up a trust is to establish this continuity, that these things can be handled privately, easily, without a court, without creditors being involved. And finally, not finally, but next to finally, the next way of looking at it is your taxable estate. Both the federal government and the states of Rhode Island and Massachusetts have inheritance taxes that they impose on estates. The federal limit right now, since President Trump became president, is now up at $10 million. So I have never had a $10 million client, so I have not, at present, have not had to deal with that. I have had clients at the lower estate tax levels of $5 million, and prior to that it was $650,000, where we had to deal with federal estate taxes. However, in Rhode Island and Massachusetts, in Rhode Island, the estate tax comes into play if the estate is about $1.7 million in Rhode Island. If it's a little bit, somewhere between $1.5 and $1.6 million, the estate taxes come into play. And many people have that. One of the reasons many people have that amount of money is that in estate taxes, the state counts everything. So even though the assets may not be going through probate, they were beneficiary assets, they were trust assets, they were jointly held assets, they still are countable for inheritance tax purposes. If you have a middle class person, particularly if they were some type of a professional person, if they own a house, if they have some life insurance, if they have been putting money away in a 401k or IRAs for a good part of their working life, it is not difficult for them to get to the $1.5 million mark and to have estate tax issues. So again, one of the things we have to do when somebody comes in and say we want to start doing estate planning with you is we have to kind of go over all their assets to determine, do you fall into the category of people who are going to have to deal with, whose estate is going to have to deal with taxation by either Rhode Island or Massachusetts, or are you safely below that threshold where we do not have to worry about writing provisions to mitigate taxes as much as possible into the documents? There is also a Medicaid estate. Now, again, we had talked about this a little bit previously. Medicaid is a program to provide medical insurance and health care coverage to people who are unable to pay for it for themselves. It is beyond Medicare, which everyone is qualified for once you become 65 if you have worked in your life. Medicare is not means tested. So Warren Buffett and Bill Gates can be on Medicare, and the person who was just a cleaning lady in a facility all her life earning minimum wage is eligible for Medicare. Medicaid has requirements that have to do with how much you have in assets. They are theoretically supposed to be below $4,000, and you cannot have given any assets away for a 5-year period prior to your applying for Medicaid benefits. Because of this, and because of people's fears of being in the nursing home and having to have their families privately pay for them, we do a good deal of planning now talking about people's estates and what would happen if one or both of the couple end up in a nursing home, and looking at assets that possibly could be given away, moved into an irrevocable trust, or in some other way sheltered, so that if one of them ended up in a nursing home facility, we could make them eligible for receiving government assistance without wiping out the entire asset base that the family had built up over a generation. So as you go forward, just realize that when you say the word estate to a lawyer or an accountant, 4 or 5 things pop into our minds. And very quickly, we're listening to you and we're beginning to categorize, all right, are they talking about a beneficiary estate? Are they talking about a probate estate? Are they talking about inheritance taxes? Are they talking about Medicaid? And different assets can fall into one or more of these categories. So it can become quite a complicated thing. And the way most people have set their lives up today, they are involved in a number of different things. They own property, they have different financial assets, they have different investment assets, retirement assets, that very often when they pass away, their assets run across a gamut of all these different estates and different ways of looking at estates. Okay, one last thing I would like to do here. As part of estate planning, I would like to talk about documents that don't really have to do with wills or trusts. They don't have to do with when you die, but they are here to assist you when you are still alive. And in some cases, these are more important than the documents that are going to handle your estate after you have passed away, because these allow you to be continually cared for without interruption or disruption. They allow family members to go forward with possibly not having to set up a guardianship on your behalf. And they allow for, again, a smooth transition or takeover if you become ill and somebody has to step in to take care of you and to take care of family members. First things that we would talk about are powers of attorney. A power of attorney is a written document whereby you nominate someone else to act on your behalf and to basically make decisions as if they were you and as if you were there. Traditionally, powers of attorney could only give whatever ability the maker of the power had to the person they have appointed. And because of that rule, if you became incompetent, the power of attorney ceased to exist because you no longer were able to handle your own affairs. You're incompetent, so you can't give power to somebody else to do it. Likewise, the minute you die, even today, a power of attorney ceases to exist because you don't exist. And the power of attorney is basically saying, I'm taking the rights I have to make decisions and I'm giving them to Harry. Well, if you're dead, you no longer have any right to make decisions. So the minute you pass away, whether Harry realizes you have died or not, the power of attorney is gone and has disappeared. About 35 years ago, the legislatures in Massachusetts and Rhode Island and some other states began looking at the cost and expense of setting up guardianships and the difficulty of the particular invasion of privacy that it is, because everything now becomes public. The person's entire financial life has to be provided to the court, and particularly in those days, it's a little bit tighter. The requirements as to who can look at these files now are a little stricter, but in those days, anybody, your next-door neighbor, could go down and peruse through years of your records in the guardianship to see exactly how much they were spending for coffee for you every month. The whole idea of a guardianship really began to work against modern sensibilities. Modern people did not like it. They didn't like that type of invasion in their lives. So thinking about this, the legislature made a change to the common law of powers of attorney, and they created something called a durable power of attorney. And when we use that word durable, what we're saying is that even if you become mentally incompetent, if you become physically or mentally unable to communicate, to deal with your affairs, the power of attorney can continue to act in your behalf. Now, in order for this to happen, there has to be language in the power that specifically states this is your desire. In our powers of attorney, we use language that basically says, in the event that the maker should become incompetent or unable to handle their own affairs, it is their expressed desire and wishes that this power of attorney continue in full force and effect. And we often quote the statute reference that creates this allowance. This is very important because this could be the difference between your spouse or loved one or relative having to open up a probate adult guardianship or being able to continue to handle your affairs even though you're no longer able to take care of them. And because people can be injured, because people can become ill even when they're young, we urge everyone who's an adult to have one of these and to have somebody named who can handle their affairs for them. Along with this, the legislature a little bit later created something called a healthcare power of attorney in Rhode Island, or a durable power of attorney for healthcare, and a healthcare proxy in Massachusetts. By statute, if anyone is going to be given authority to make medical decisions for you, it must be by way of this particular power of attorney, this particular proxy. The general durable power of attorney that we can draft to cover any other situation in the world by statute does not work in medical situations. In Rhode Island, the healthcare power of attorney allows you to name one principal and two alternates, and it allows them to basically make any decision involving your healthcare up to including pulling the plug, stopping services, stopping the provision of medical care if they feel that that is no longer warranted. There are provisions in both Rhode Island and Massachusetts. These documents are pretty much set by statute. The actual form for them is in the law books, and if we want to make sure that they're going to be accepted and be usable, we try to follow as tightly as we can the statutory framework. There is, in Rhode Island in particular, provisions to allow you to put in specific instructions so that if there are certain things that you want to have happen or not have happen to you, we can write that right into the power of attorney and their effect either increase or limit the authority that your attorney in fact would have. And that's what we call the person who is appointed in these documents. Both the power of attorney for finances and the healthcare power of attorney are called an attorney in fact. One thing that we need to make clear about healthcare is that even if you have signed a healthcare power of attorney, if you've signed a living will, which we'll discuss in a minute, if you are awake, if you are conscious, if you are competent, you are always in control of your own health decisions. I tell my clients when explaining to them that even if you're lying on a gurney and all you can do is blink once for yes, two for no, you are still in control. The power to make decisions for you only passes to another person when you are in such a physical state that, or mental state, that we are unable to communicate with you. We're unable to determine what your wishes are. All right. In addition to a healthcare power of attorney, a document that was actually created prior to the healthcare power of attorney is something called a living will. I hate the name of this document because it's not a will at all. But somebody at AARP, the American Association of Retired Persons, or some other seniors group 40 years ago, came up with this idea, stuck this name on it, and it has survived. As a matter of fact, when I'm dealing with extremely elderly clients, very often they come in, and the first thing they're asking for is, I finally decided I need my living will, it's time, I want it. A living will is your statement as to what type of medical treatment you would want or not want if you were near death, and you are again unable to make that decision for yourself. You're either unconscious or mentally you're unable to make a decision on that. And in the living will, you can basically state anything from I want to be kept alive forever, do everything you possibly can to if there's not a great likelihood of my recovery, I don't want any medical treatment whatsoever, just keep me comfortable with pain medication and let me go. So it is your statement as to end-of-life treatment, what it is that you would desire and not desire. I have seen people pick all different realms. I had one little 85-year-old lady who had 5 heart attacks say that she wanted to be absolutely kept alive no matter what. I've had 30-something people say, well, if I'm going to have a bad quality of life, I don't want them to resuscitate me, I don't want them to revive me, just let me go. They are highly personal decisions. I happen to like the healthcare power of attorney better because with the healthcare power of attorney, you have a live person standing there waving the paper at the doctor saying, we're about to do this. Whereas with the living will, you have a document in your file that you have possibly signed 15 or 20 years before, and now you have 2 or 3 young residents trying to figure out, well, what did they mean by that in terms of the modern procedures that we're about to apply? How does this living will fit into all of this? I have, in recent years, though, come to appreciate the living will in that one of the things that people run into with the healthcare powers of attorney, mom is unconscious, she's lying in the hospital bed, the doctors are proposing some radical procedures that may or may not work, and the person who usually is a spouse or very often is an adult child who's been named to make the decision says, well, mom's elderly, there's not a great likelihood that she'll become conscious after this. There's not going to be a likelihood of her quality of life. I would prefer we don't do the procedure. Emotions are running rampant at this point in time, at these points. The family is already usually in the midst of tragedy and disaster because mom is in the hospital. So it's an emergency. Everybody is very on edge, uptight. And then all of a sudden, if there are multiple siblings or multiple people involved, all of a sudden you have somebody saying, you're going to kill mom or you're going to kill dad. How can you do that? How can you be horrible? This is awful. And I have had clients for whom I have written very detailed healthcare powers of attorney so they'd be able to deal with situations for parents or a spouse, come back after the person died and tell me, I had to let them do those procedures. My family was just so vociferously arguing that I couldn't kill my relative, that I just couldn't deal with the emotions of it. So one of the things I found is very interesting is that having a living will to back up what the attorney, in fact, under the healthcare power of attorney wants to do is sometimes very helpful, because now, as other people are moaning and groaning that you're going to kill mom, we can pull a copy of this out of the file and say, look, there's mom's signature. This is what she wanted. So your choice now is to tell me either I'm killing mom or I'm not doing what she wants, or what she had wanted, or what she had desired for herself. And sometimes that helps to smooth out family issues where it otherwise would have left very difficult feelings if the person in charge had gone on and made the difficult decision while others were objecting to it. A couple of words of advice, and just dealing with things that come up in this. A living will and even your healthcare power of attorney are not do not resuscitate orders. A do not resuscitate order is a document that says, if I am unconscious, and particularly if I have stopped breathing or my heart has stopped, do not revive me. Do not resuscitate orders, by law in Rhode Island and Massachusetts, are only supposed to be in place if the person has a condition which could likely cause their death within a year. Now, I know that rule is very seldom followed, because hordes of my clients, elderly clients, are walking around do not resuscitate orders in place, and they happily bump along for 2 and 3 and 4 and 5 years with them in place. So I know that these things are not being handled or administrated exactly along the rules set by the statutes. We rarely do not resuscitate orders in our office, because one of the other requirements of a do not resuscitate order is that a doctor or other medical personnel has to explain in detail to the patient, to the person, exactly what this order means, and the doctor must also sign off on it. Because of the fact that doctors and lawyers are seldom in the same room together, really don't like to be in the same rooms together in most situations, we end up not working on do not resuscitate orders. They tend to be something that is done either in the family practitioner's office with somebody who has a long-term illness, or very often they're done in the hospital after somebody has presented in an emergency situation and there's some question as to whether they're going to survive or not survive, and then the issue becomes, well, what type of treatment, what type of invasive things do they want or not want? So just be aware of that. Your healthcare power of attorney and your living will are something distinct from a do not resuscitate order, which is another step in this whole process. There is a federal statute called HIPAA, which is short for the Health Insurance Portability and Accountability Act. It was passed about 35 years ago now. The goal of the act was to make it easier for us to carry our health insurance from one employer to another employer without worrying about periods of ineligibility and worrying about having pre-existing conditions not accepted by a new employer. The act really didn't do a lot to help those things, but it created several hundred pages of privacy rights that are now imposed in all medical treatment situations. Under HIPAA, family members are not entitled to get the medical records of other family members unless there has been express consent given for that. I personally feel that under Rhode Island law, the healthcare power of attorney that we have is sufficiently broad to say that I am the power of attorney for HIPAA release information as well as for making medical decisions, but our clients have had hospitals and doctors and clinics argue with them on that part, although I don't understand how in a logical world you can expect somebody to make a medical decision if they're not allowed to see the records upon which they need to base that decision. However, be that as it may, the world does not always work logically. If it did, there'd be little need for lawyers. So as part of the package that we put together for our clients, we now also have a HIPAA authorization form that whoever they have named in their healthcare power of attorney, we also name in this form that provides for the release of medical information for medical records, and basically makes it very clear to whoever's providing health care to the person that the persons who are named as the healthcare powers of attorney absolutely positively have the right under both federal and state law to see the medical records and to be apprised of the medical condition of the person who they are trying to take care of. All right. Going back to just regular powers of attorney. A power of attorney for financial matters, and I have given you a sample of a general durable power of attorney that tries to cover everything. It's a number of pages long. It covers all types of bizarre transactions because we have had situations where something is not explicitly named and stated and talked about. Various companies, banks, insurance companies, annuity companies will refuse to deal with the person who's been appointed. One of the realities of life is that banks and other financial service companies do not like powers of attorney because they run the fear that, oh my God, we're going to let somebody come in, play with this person's money, rearrange their assets, and what happens if they wake up and decide they didn't like that? Are we going to get sued? So they put all kinds of roadblocks in the path of an attorney, in fact, who's trying to deal on behalf of the family member or relative who has nominated them. The durable power of attorney for financial matters must be signed, must be notarized, and whoever is utilizing that document has the absolute right to see the original with the wet signature of the person creating the power, the wet signature of the attorney, with the attorney's seal affixed to the document. We urge our clients to never let these folks keep the document even overnight because they have a wonderful way of losing them, and if the person has become incompetent, then we have difficulties where now we can't get it recreated. So what we advise our clients to do is, yes, you have to bring in the original, you have to show them the original, let them see it, have them scan it or take a copy of it. Do not leave their office without the original in your possession. The same type of restrictions and roadblocks are beginning to apply with guardianships as well. Under Rhode Island law, for nearly 400 years, once a guardian of an adult or even of a minor is appointed, you receive a letter from the probate court, which basically has all the court captions at the top and says, "Greetings. You have been appointed the guardian of the person and property of John Smith." Boom. Period. That is it. Needless to say, in many other jurisdictions, the letters of appointment are far more detailed, far more complicated than that. And in the last 10 years or so, we've been running into more and more issues, particularly with the nationwide banks, that when we go through all the work to get a guardianship created, the guardian goes in to attempt to use it to get money out of the bank or to set up an account for the ward, and they're being told that, oh, that letter's not enough. So on a number of occasions, I have had to go back, I've had to call the bank, call the insurance company, say, all right, exactly what wording do you want in the order? I have to draw up an order, then I have to go back to the probate court, present it to the judge, and ask the judge to sign it so that we now have a very specific order saying that Mary Lou, the guardian of her mother, Mary Smith, can rearrange the assets in ABC Bank as approved by the probate court. So just be aware of that. They do not like these general guardianship letters just as much as they don't like the general durable powers of attorney, and they make it difficult for people to use them. It is just part of the process. In our office, we always tell folks we make ourselves available, that if you run into these issues, call. One of the attorneys will get on the phone, will speak on your behalf, and we'll argue with the person on the other side if need be. Besides general durable powers of attorney, there are also specific powers of attorney. And because I deal in real estate very often, most of my practice is real estate, I deal with specific powers of attorney all the time. What these are used for is where there's a certain event that's coming up, such as a closing on a piece of real estate or the refinancing of a piece of real estate, and the owner, the principal, cannot be there. Then they can nominate a person, very often it's me, to go to the closing on their behalf for the specific purpose of signing and delivering the documents of that closing. I can't get into their bank accounts, I can't look at their IRAs, I can't rearrange things, but for the purpose of at least going to this particular closing and handling this particular transaction, they can appoint me to do this. This has become more and more important as time goes on because we have more and more Rhode Islanders who retire to Florida or Texas or Arizona, but still have property interests here, and they don't really want to fly back just to handle a closing or a refinance of those things. They also have, there are also more situations where today the banks have basically reached a point where they will tell you when you're going to close, and sometimes it's less than 24 hours notice. And very often I have clients who, they're doctors, they're lawyers, they can't tell the judge, they can't tell the person lying on the operating table, oh, I have to leave and go sell my property right now, sorry. So if we're getting close to a situation and it looks like the bank is behaving that way, we're not going to know exactly when the closing is, and we might be called up in an hour or two notice. And again, very often I will suggest to my clients that they give me the power of attorney to go to the closing for them. So therefore, they can continue on with the things that they have to do, and I can take care of this if it comes up as a unscheduled, sudden matter. All right. There are new things happening because of COVID-19. The state of Rhode Island, at least on an emergency basis, for the first time has approved internet and remote observation notarization. I have just, as of yesterday, received my approval to go ahead and to set up notarization, doing notarizations this way. I have to read through a whole host of how that is to be done. They have imposed all kinds of what seem to be rather Byzantine and bizarre requirements for that to happen, but it is happening. So the way that we handle transactions for real estate, the way that we execute documents like powers of attorney, are changing dramatically, even as we speak, even as things are going on at the moment. So far, there is a petition, and there are letters before the legislature and the governor requesting that the rules for execution of wills also be changed, but so far that has not happened, and it appears that it will possibly take an actual act of the legislature for that to occur, whereas the notarization is under the control of the Secretary of State and the governor. So without waiting for the state legislature, they were able to adopt emergency regulations that allow them to move forward and to allow the reality of the internet and the reality of face-to-face Skyping or Zoom meetings or whatever, where people actually can see what's going on, and to acknowledge the e-signing that is actually taking place in large areas of contract and business law, but still has not really come into real estate or estates and trusts fully. So, all right, with that, we are done. Keep going to Blackboard to stay up with the latest assignments and the latest postings of what's happening. There will be no more lectures after this. I thank you all for participating. I am sorry that the last half of the semester had to be done this way. I really appreciate being in the classroom, talking to you folks, dealing with you folks. If there are any questions, please email me, call me. The numbers have been posted and are available to those of you who are my students. And with that, carry on, stay safe and healthy. As I said, keep looking at Blackboard to find out what the rest of the assignments are for the semester, and carry on.